Namaskar, me Advocate Omkar Modhave, and today we have Advocate Sachin Zalte-Patil, who is a senior advocate, and he is here to provide us with valuable insights of legal trending and emerging topic of NDPS. We have seen in various cases of Riya Chakraborty and a recent Pune rape case that NDPS Act has been came into action in courtroom, and today Advocate Sachin Zalte-Patil is here to provide us with valuable insights about the same.
Namaskar.
Sir, can you provide a brief history of the NDPS Act and why this act was enacted?
Generally, what happens that there is a provisions for the IPC, but what happens that these offences like consumption, selling, storage, these of this NDPS offences like narcotics, drugs, and psychotropic substance. So to curtail this menace in the society, because this is an anti-social activity, because one person's get addicted, its effects on his social life, also in the mental life. So to curb this menace from the society, generally IPC is not sufficient to curtail this problem. So whenever the general laws like IPC and other laws are not sufficient to curb this problem, so we have to enact such a special laws for that purpose, and therefore to curtail this menace and to regulate the trafficking of these drugs in the society. This law has been enacted in a year of 1985 with that intentions.
So, as you said that to take control on trafficking of drugs and all other illegal substances which are commonly known as contrabands, this act was enacted. But do you think or do you believe that this act achieves its goal efficiently?
Yeah, rightly, because in this act there are several stringent punishments, like from 6 months to the 20 years punishment is there. There is a fine in lakh rupees. Not only that, if you are repeating the offences time to time, there is a death sentence also provided for that. So I am of the opinion that due to this enactment of act, the problem of the society becomes minimized.
Okay. So problem tackling is one of the key features of this act. Also, stopping drugs or drugs uses is its goal.
One of the aim of that.
Yeah. So the NDPS Act is also known for its stringent provisions. So could you elaborate on what makes this law so strict compared to other criminal laws in India, like Indian Penal Code or newly enacted BNS, BNSS or other acts?
In this case, like NDPS cases, there are several sections. For example, Section 8, Section 90, Section 24, Section 27, there are several amendments. But these sections are particularly depends upon the which provisions you have violated. For example, for the consumption, there is separate punishment. For the storage, there is separate punishment. Cultivation, there is separate punishment. So interstate traveling, there is separate punishment. So depend upon the act which the person has been committed, punishment is there. And now this basically punishment is based upon the quantity. Like there are 3 quantities of the contrabands. One is small quantity, another is intermediate quantity, and third one is commercial quantity. So now what is small quantity, what is intermediate quantity, and what is the commercial quantity? It is to be, we have to look into the notifications which is published by the central government. So when the, suppose for example, like this person is found with a possession in the contrabands, and if this quantity is a small quantity, for example, now punishment is only for the 1 year. Now it is the intermediate, right? Again the punishment is of the 10 years and the fine amount is to the 1 year. And if it is a commercial quantity, then the punishment is 20 years. So depending upon the quantity of that contraband, the punishment increases. Because as you know, If it is for the purpose of commercial purpose, you are going to sell it, so definitely there should be a stringent punishment. And if also, if a second time offender has committed the offence, first time he has committed, again second time he has committed. So the main object of this act to curtail the problems in the society. Unless and until we increase the punishment, their punishment should be a stringent punishment. Otherwise, it is like a toothless tiger. This is not toothless tiger. If you are repeating the crime, there should be punishment, stringent punishment. So, second time if you committed offence, punishment is done. And if the like a interstate trafficking, you are committed an offence, and again you are committing interstate offence, or from the outside India you are bringing this contraband, and already you are convicted, again and again you are convicted, death sentence is also provided for that. So this is not a toothless tiger. There are stringent punishments are there, but depending upon the quantity, what act he has committed.
Okay, sir. As you explained, the stringent punishments are there, but this act is also known for its very different classification of reverse burden of proof. So, could you explain that what is reverse burden of proof and how it is proved in NDPS Act and how it impacts the accused in overall process?
Generally, in the general parlance, it is in an Indian society, so far as our criminal trial is considered, the burden is always on the shoulder of the prosecution. He has to prove his case beyond the reasonable doubt. But certain times, this presumption is a reverse presumption. Certain times, we carve out the exception to this presumption. General presumption is that prosecution should prove their case beyond reasonable doubt. But there is exceptions carved out, and in these cases, burden shifted on the shoulder of the accused persons. There is a presumption that he has committed an offence, section 54. And also there is sections of 35. It says that there is a mental condition. It is presumed that there is a mental condition of person, he knows and he has a conscious possession of that. For example, suppose accused person is found with his pocket some contrabands, whether it is small quantity or commercial quantity. Now he may say that I have no intention to sell it or to traffic it. But whether he has intention or not, it is within the mind of that person. So generally, it is very difficult to look into the mind of the person and to get that his intention. So when facts are within the knowledge of, generally these facts are happens within the knowledge of that person's soul. So he has to explain that how he bought, for what purpose he bought, from whom it was bought. So the burden shifted on the shoulder of that person, and there is presumption of mental state, including motive, intention, everything. In section 35 is very clear about that.
Sir, as you mentioned, a very strong term, and that term is used in various High Court judgments. The term is conscious possession. So recently in a case where High Court had said that mere possession will not amount to offence. So could you explain about significance of conscious possession and how it is proven in court and how to disprove it?
Everybody knows possession. But what do you mean by conscious possession means that you are aware about this fact. For example, somebody has put some contraband in my pocket. So, though I have possession of that contraband, but whether I know that this contraband is in my pocket, no, because some third person has put it in my pocket. So I am not aware about that. So conscious possession means what? These possessions of this contraband is within the knowledge of that person. It is called as conscious possession. So whenever the prosecution is to prove, they have to prove not only the mere possession, they have to prove the conscious possession, because the accused must aware with the said fact. This is concept of conscious possession.
Okay, sir. And if the possession is not known, so it will not amount to conscious possession.
It depends on the right person. I am not having conscious possession. Somebody has planted it. I do not know. But that depends has to be proved by the defense.
Okay, sir. It is well known that bail under NDPS Act is very difficult to obtain. and accused or even the victims who are falsely implicated find it very difficult to get bail. So, what are the specific conditions under Section 37 of NDPS Act which make bail a rare possibility?
See, as I have already narrated or told you that the Act has been enacted with intention to curb the activity of this drug trafficking. So, if a person easily gets the bail, so the intention of legislature will get trusted. Unless and until we make the bail punishment, the provisions of bail stringent, so it becomes a toothless tiger similar. So the persons once committed offence and he prima facie appears that he has committed offence, so he should not be bailed out, right? Because it is anti-social, the offence. So the legislature has enacted the provisions of Section 37. It says that if the court has reasonable reasons to believe that this person is guilty of offence, then there are twin conditions. First condition is that if the court has reason to believe, so who has to kill the court has to kill this. If this person found guilty of an offence. And second thing is that the second condition is that if the court deems fit that his person is going to commit repeated offences, under these circumstances there is bar for the bail. So this Section 37 is a bar for the bail. But though there is a bar, but this is not for all offences. This is only for the offence of Section 90, Section 24, Section 27A. That is the interstate, outside the state trading, and also if the person has financially aid to this the illegal trafficking act, and also if a commercial quantity is there. See, I have already stated you that if a small quantity is there, even you found any of the drugs, say contraband. If small quantity is there, the punishment is only for the 1 year, 6 months, so it is considered as a bailable offence. So you will get the bail as a right. But if it is an intermediate quantity, comes to the intermediate quantity, and what is intermediate quantity depends upon the chart that is notified, because there is no such as formula. It is, we have to observe in the notification. For MD there is different quantity, for ganja there is different quantity, cannabis different quantity. For every contraband there is a different quantity for small, intermediate and different. Once it comes within the intermediate quantity, now punishment is 10 years. But still there is no bar of Section 37. It is bar is only for the commercial quantity, Section 37. And it is correct, because if person is doing such an act with a wide, huge commercial quantity, so there should not be a bail, because their punishment should be stringent. And in that circumstances, even there is a bar of Section 37. But certain times, even a Supreme Court and High Court has released the accused persons, because this bar is not an absolute bar. If the accused person successfully brought into the notice of the court that the provisions of Section 41, 42, compliance of stringent provisions has not been complied, there is inventory has not been, the information has not been registered, and if there is any lacunas in the investigation, so there is no bar of Section 37. So this is not absolute bar, but if court come to the conclusion that there is sufficient material and reasonable grounds to believe that this person would be guilty of offence and he is having criminal antecedent, there is no bail for this person.
So sir, what are the specific or reasonable grounds to believe that the accused is not guilty, and how the same thing is practiced in courts, as you have handled many cases?
See, this is not like a prima facie case. See, this offence is itself a technical offence. Like, for example, if any secret information has been received, that information has to be written down by the police officer. This is the compliance of Section 41. And if the person's got a secret information, then he has to get the search warrant for that. He has to comply with that. And then after the section 50 compliance is there, because every person has the right that he should be searched before any gazetted officer of the magistrate. But this compliance is not an empty formality. This is incumbent. These are not mere directory. These are mandatory. And if this mandatory provisions has not been used by the prosecutions or there is no compliance at the hands of the investigation officer, definitely if these are not mandatory, mandatory provisions have not been complied, so that means that persons would not be guilty. So if the courts believes that this compliance has not been complied by the police officers, then there is no guilt. So in that circumstances, court will grant a bail.
And what are other conditions or some other circumstances where
The important thing is only section 41, section 42, section 50, that is a compliance of the search and seizure. Second thing is section 52, that is inventory. That inventory should be there. Sampling of that sample has to be carried out and it's to be sent to the CA report. And second, the important thing is section 57. There is, if this information has been received by the police officer, they have done such action, they have carried out the raid, but that or everything has to be informed to the superior officers immediately. If now this compliance has not been section, recently one of the judgments said that the section 52A, that is a sample, is to be withdrawn before the magistrate. It is called inventory. It is compulsory. Now in that judgment, it is the sample has been collected by the police first. So courts observe that police has no right to take the sample, only the magistrate. So inventory has not been done completely properly, and court has given the benefit of that, and court released the persons on the bail, irrespective of there is a provisions of section.
and it was believed that it was a very
It is a ground, reasonable ground that you will not be guilty.
okay. So have been there any specific or recent Supreme Court or High Court judgments which have liberalized bails?
We will
in
discuss
NDPS?
it at the end of the point, because there are so many judgments. Riya Chakravarti recently, also in one of the Khan's judgment. So we will discuss that one. Riya Chakravarti judgment is very clear on this point.
So, how does the punishment vary significantly for each of the classifications? Like, as you said, that there are different punishments for different quantities of contraband found. So, how are the punishment affecting whole trial or the bail system?
Definitely. See, when there is a provisions for the bail, so what is the amount of punishment is one of the criteria. If there is a life and death punishment, then there is no provisions for the bail, or the bail will not get easily. So if it is a commercial quantity, for that purpose punishment is 10 years minimum, and it may extend to 20 years, and there is also fine amount of in the lakhs. And also if you are repeating the crime, in that circumstances there is punishment is also enhanced, and also to the death punishment. So the stringent punishments are there. And if the punishment is like life, 20 years, definitely it comes within the purview of the section 37, and you will not get a little better.
Okay, so
Not only that, there are also certain provisions. Suppose, for example, any person who has a land and he has cultivated such a coca plants, like Canadian plants, and also the poppy seeds, straws. So, if this has been cultivated, so this is comes under also this NDPS Act, because if you want to cultivate that, and certain times this poppy seeds, like and the coca plants, that can be used for the medicine purpose.
yes.
That can be cultivated. But without prior permissions of the government, you cannot cultivate that land. Not only that, if any person who is possessioners of the land and he has not provided information that somebody else persons